Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. The maritime law as environmental protection, the management in study case of sustainable operation to control emission in maritime transport in ECA area, part 2. In regarding of the most favorable methodologies involves new technologies to be applied in emergent form of analysis of the collected sample of fuels, aiming to help the grid demand control in supplying ships to minimize emissions of greenhouse gas every step shipping globally. Specifically, in the event of inspection equipment of foreign vessel in Brazil under the aegis of our 226 226 Paragraph 1 admits to inspection equipment of foreign vessels from port states. However, inspection should be limited to examination of the certificates, records, and other mandatory documents. In Brazil, VR5 of Law 9537/97 informs the foreign vessel subject to naval inspection to submit irregularities in the documentation or poor operating condition representing threat of harm to the environment, the crew, to third parties, or to the safety or maritime traffic can be ordered to not enter the port, does not leave the port, out of the territorial waters, veer away in national harbor. However, according to UN clause in the inspection case, more incisive material in the vessel's oil, this can only will be undertaken after examination in case of evidence of irregularities or omissions in Article 202 in Article 226 paragraph 1. Octaviano Martins 2008 has described this assumption are admissible only if there are clear grounds for believing that the condition of the vessel or its equipment does not correspond substantially with the particulars of those documents. Second, the content of such documents are not sufficient to confirm or verify a suspect violation, or the vessel not carry valid certificates and records. Verify the offense. The retention time of the vessel shall be limited to the minimum unless there is a risk of serious harm to the marine environment, with the flag state to be informed without delay. According to Octaviano Martins 2008, in such a case, if the investigation is a violation of applicable laws and regulations or international rules and standards for the protection and preservation of the marine environment, the vessel will be immediately released after serving subject to reasonable procedures such as provision of a bond or other appropriate financial security. Art 226 1b. In Brazil, according to Octaviano Martins 2015, it is common to use the vetting system for the adoption of evaluation and acceptance of ships adopted by all port terminals and bulk cargo shippers, particularly oil and its derivatives. For example, the vetting establishes minimum standards that allow access to shipping terminals observing basic rules of quality, safety, and environmental protection. According to Octaviano Martins 2015 in Brazil, the vessels are examined considering the characteristic and the shape of the state in terms of preservation or installed resources. So, before they begin operation in ports, it is possible to evaluate legally the facts that lead to technically complete forms to be admitted in the environmental assessment, which criteria determining the energy potential of the vessel for in terms of assessing their potential sorry, their potential eco-efficiency, accept, safe, deleterious effect on the admission by type of vessel in Brazilian waters. However, without prejudice to the international rules and standards relating to seaworthiness of vessel may be denied the release of a vessel or be subject to the requirement for the vessel to address the closed shipyard to repair whenever the same release represents unjustified damage to the marine environment. If the release has been refused or made conditional, the flag state shall be promptly notified and may seek release of the vessel. Art 226 1c. According to the preceding analysis, it is necessary to reiterate that in the event of discharge made in inland waters, in territorial waters, or exclusive economic zone of another state, the port state where foreign vessel may open investigation and bring procedural requirements only if led to discharge or can lead to contamination of their own waters or other state which has been or may suffer damage from this discharge or this flag states so request. Article 218 AL 1 and 2. The state port shall endeavor to satisfy the issue survey request by any other state whose waters have been polluted by the ship is in its port, and also the survey request occasionally present by the flag state of the vessel. Article 218 AL3. In addition, the state port may prohibit foreign ships which have violated international rules and standards with regard to seaworthiness of vessel and can therefore cause damage to the marine environment to harness until they have been eliminated the causes of the offense. Art 2019 184. It is noteworthy that, whatever the circumstance, to exercise their right and performing their duties under this part, states shall not discriminate in form or in fact against vessel of any other state. Art 227. If the coastal state pursues a foreign ship, the measures taken by it shall be notified to the flag state. Article 221. If the on-flag state pursues a foreign ship as a result of the same offense, the persecution of the coastal state should be suspended unless the offense has been committed in territorial waters of the latter, or in the case of serious injury, or in short, that the flag state has repeatedly missed its obligation to ensure the effective application of the relevant rules. Article 228. According to Fernandez, 2004, should not only analyze the economic issue merely to corporate survival, we have to expose the personal scale forms of risk to cover the technological risk of the companies. In regarding that, Fernandez 2004 said in the EU the certain norm, very similar to the Brussels polluter pays principle, is applicable. For Colombo 2006, the polluter pays principle has three primary functions: the prevention, repair and redistribution, and internationalization of environmental costs. This type of public policy involves the need to clarify the commitment of companies, like the problem is addressed above all to make himself understood the process. Fernandez 2004 explained the idea when it has applied form is as follows. The first phase is mainly focused on check compliance with verification of compliance management. The second phase relates to observe the development of improved identification system. And in the last phase, aims to promote leadership position for sustaining and effectiveness of policies implemented during the process. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one. Bye bye.